before you fly, especially if you are not a U.S. citizen. Watch this first. A routine domestic airport trip can turn into a serious immigration moment if you're unprepared, particularly if you have a pending case, a prior issue in your immigration history, or anything in your record that could trigger extra questions. Welcome back to the live stream. It's Monday, March 26th, 2026, and tonight I'm here to give context, answer questions, and talk through the immigration topics that are coming up most often right now. I'm an immigration attorney, and I've been practicing law for more than 2 decades, with a long-term focus on immigration matters. I work with people across the country and internationally, so if you're watching from outside Michigan or outside the United States, feel free to say hello in the chat and tell me where you're joining from. And if you have questions, post them as we go. I'll try to address as many as I can. Quick but important disclaimer. This is general information for educational purposes, not legal advice. Immigration outcomes depend heavily on individual facts. Policies and enforcement practices can shift quickly, and even when the law doesn't change, real-world implementation can vary by location. If you have a high-risk situation, such as a prior removal order, a past unlawful entry, an overstay, or a criminal issue, get individualized advice before making travel or filing decisions. Now, the biggest topic I've been asked about today involves reports and traveler discussions suggesting a more visible immigration enforcement presence at some major airports. I've received messages all day from people asking, is this real? Does it mean I can't fly domestically? What if I'm waiting on an application? What if I had an old issue years ago? Those are fair questions, and the reason people are nervous is also fair. Airports are not normal public spaces. They're unique environments where security screening is routine, identification checks are common, and multiple government agencies operate in the same footprint. Let's be careful and precise about what we can say. I cannot independently confirm every claim circulating online, and lists can change. But I can talk about the practical risk. If an immigration officer is present in an airport environment, they may have the ability to ask questions and take action in ways that you typically don't encounter during everyday life. Even without any new policy, the airport setting itself can raise the stakes for someone who has unresolved status issues. So, who should be the most cautious? If you're a U.S. citizen traveling domestically with valid ID and no unresolved legal issues, this likely doesn't change your life. You may never notice anything beyond normal airport security. If you're a lawful, permanent resident with a clean history, valid documents, and no unresolved problems, your risk is generally low, but you still want to travel with your green card and identification and avoid casual assumptions like, nobody can ask me anything. Airports are controlled spaces. It's always wise to be prepared. Where the risk rises is for non-citizens who fall into one of these categories. If you have a pending immigration process and you are not yet a lawful, permanent resident, you should think carefully about domestic travel. That does not mean never fly. It means do not treat flying like taking a bus across town. Be prepared for questions, be prepared to show valid identification, and understand what you will say if approached. If you have any past negative immigration history, your risk can be higher. That includes prior removal or deportation orders, prior denials, prior unlawful entry, prior overstays, prior fraud findings, or anything else that could appear in an immigration record. Even when an old issue is in the past, the key question is whether it was actually resolved in a way that makes you safe today. If you have a criminal history, even if you believe it was minor or dismissed, do not assume it's irrelevant. Immigration law treats certain arrests and convictions differently than criminal court does. The safest approach is to have a qualified attorney review your specific history before you put yourself in a high scrutiny environment. If you're someone who is out of status, or you believe your status is unclear, that's where the risk is most obvious. If you have no lawful status, and you enter a place where enforcement officers are present, you are increasing the chance of an encounter you cannot control. Now, let's talk about the airport list issue because people keep asking. A list circulating online has named 14 major airports as locations where there may be increased immigration enforcement visibility or support. I'm going to emphasize again, treat this as unverified chatter, unless you confirm through official sources or reliable reporting. But the airports frequently named in these discussions include Chicago O'Hare, Cleveland Hopkins, Atlanta Hartsfield-Jackson, two major Houston airports, JFK in New York, the major New Orleans airport, San Juan in Puerto Rico, Newark Liberty, Philadelphia International, Phoenix Sky Harbor, Pittsburgh International, and airports in Southwest Florida and Fort Myers. If you are traveling through any large international airport, whether or not it appears on a list, assume enhanced authority exists in that environment and plan accordingly. What should you actually do if you're concerned? First, don't panic and don't self-sabotage. Panicked decisions cause mistakes. The goal is calm preparation. Second, carry the identification you are legally required to carry. Citizens should carry appropriate government ID for flying. Permanent residents should carry their green card. Non-citizens should carry the documents that reflect their current status if they have one. If you have a pending case and you have receipt notices, it may be useful to carry copies, but do not assume a receipt notice equals lawful status. It may or may not. The meaning depends on the filing type and your underlying status. Third, think about your risk profile honestly. If you have a prior removal order or unlawful entry, this is not the moment to take advice from random comments online. Get a real assessment. Many people do not realize they have a risk until they're already in the encounter. Fourth, limit unnecessary travel if you are high risk. If you're flying for a vacation you can reschedule and your history is complicated, it may be smart to delay travel until you get a legal review. That's not fear, that's risk management. Fifth, remember that airports operate with cameras, secured zones, and heightened authority. This isn't the place to argue or escalate. If you are approached, stay calm, be polite, and do not volunteer extra information. If you're in a situation where you need legal advice, ask to speak to a lawyer. Now let's shift into questions because I've seen a flood of them today. One common question I keep seeing is from U.S. citizens who filed an I-130 for a spouse and are waiting far longer than expected. If you're in that situation, your first step is to check your case status and your posted processing time based on the service center handling it. Most official processing tools will also show you a date, sometimes called an inquiry date, which is when the system considers your case outside normal time. If you've reached that point, submit an inquiry through official channels. If you haven't reached it, you can still inquire, but you may receive a generic response or no substantive update. Also remember, a long wait does not automatically mean a denial is coming. It can simply mean backlogs, staffing levels, internal routing, or additional review steps. But if the case is truly beyond normal time, and especially if there are urgent humanitarian issues, you can discuss escalation options with an attorney. Another frequent question tonight is about K-1 fiancé visas and adjustment of status timing. If you entered on a K-1, married within the required time window, and you're eligible to adjust status, generally you do not want to sit on it. File promptly and correctly. The longer you wait, the more you increase exposure to paperwork problems, missed notices, and changes in processing timelines. Also, if you need work authorization or travel authorization, delaying the filing delays those benefits too. The key is file correctly. A rushed, sloppy adjustment package can create RFVs and delays that cost you more time than you thought you were saving. Assemble the application carefully, make sure your documents are consistent, and keep copies of everything. A tougher question that comes up a lot is aggravated felony and whether a person can return after deportation. The news-neutral answer is it depends and it can be extremely difficult. Aggravated felony in immigration law is a term of art, and it can cover a wide range of convictions. Some scenarios create permanent type bars or very limited relief. Others may have a pathway after a long period and a waiver depending on the facts. Because the consequences are severe, this is not something to crowdsource. A person should get individualized legal analysis based on certified court records and immigration history. Another question: does limited travel history affect the chance of getting approved to visit a fiancé while a fiancé petition is pending? Travel history alone is usually not the deciding factor. The practical question is whether the traveler has the correct visa if one is required, and whether the traveler can convince an officer they will comply with the terms of entry, meaning they will leave when required and not use the visit to bypass the immigration process. Border decisions involve discretion and are fact-driven, so there's no guarantee. But "I haven't traveled much" is not automatically disqualifying. Now, another topic. People asking about visa pauses, country restrictions, or temporary holds and when they end. The hard truth is governments rarely give clear end dates. If a policy is being challenged in court or reviewed administratively, timelines can be unpredictable. If someone needs a workaround, it depends on the person's eligibility and the exact restrictions involved. Sometimes lawful alternatives exist, sometimes they don't, and some workarounds people suggest online are simply not legal. So again, be careful. I also see questions about whether people should worry about detention during an interview when they entered legally but are currently without status. This is fact-specific. Many adjustment interviews are intended to complete the process, not to create problems for eligible applicants. But if a person is out of status, has prior violations, or has any enforcement flags, the risk can change. If you are in that category, you should not walk into an interview hoping for the best without a proper review of your file. VAWA's timelines come up often too. I did biometrics, when will my work permit come? Processing times vary. Many applicants see work authorization within a few months after biometrics, but it can be longer depending on backlogs and current workload. If it's far beyond typical ranges, it may be time to check whether an inquiry is appropriate. I also get questions about online marriages and fiancé visas, especially marriages performed remotely. The key rule is simple. If you are legally married, you are not eligible for a fiancé visa. Fiancé visas are for people who are not yet married. If the marriage is legally valid, the process is usually a spousal pathway. Beyond that, remote marriages can create additional evidentiary questions, and some visa categories have meeting requirements that matter. If someone is in that situation, they should get advice before filing, because filing the wrong category wastes time and creates avoidable denials. A lot of people ask about travel bans or country lists. These lists can change, and not everyone keeps them memorized. The safe approach is to rely on official announcements and to verify whether a specific country is currently affected by a specific policy, because a ban can mean different things. Immigrant visa limitations, non-immigrant limitations, additional vetting, or other restrictions. If a country-based restriction is in place, it can stall cases that require overseas processing. Another common question is about DACA and whether a U.S. citizen sibling can help. U.S. citizens can petition siblings, but sibling categories often take a long time. Also, DACA recipients may have additional issues to analyze, such as lawful entry and admissibility. In many cases, a petition can be filed to start the clock, but the overall strategy should be built around the person's full immigration history. The worst outcome is when someone files the wrong thing, triggers problems, or relies on incorrect assumptions about how DACA interacts with permanent pathways. Then there's conditional green cards and removal of conditions. If you have a 2-year conditional green card, you must file the petition to remove conditions with strong evidence of a real marriage. This is not the stage to submit only a few photos and hope it works. If that petition is denied, the consequences can be serious. Do it carefully and with the right documentation. Shared financials, shared residence evidence, joint responsibilities, insurance, taxes, children's records if applicable, photos with context, and anything else that supports a bona fide marriage. People underestimate this stage and then are shocked when they receive an RFE or denial. Another question tonight involves minor children of U.S. citizens. If a U.S. citizen parent files for a minor child, timelines can be better than adult categories. But timing matters. Turning 18 can change classification in certain contexts, and delays can increase. If someone is close to age cutoffs, it's important to file promptly where eligible and to understand the category rules. I also want to address a small but important point about receipt notices and case filed statuses. Sometimes people file an I-130 and I-485 and then say, "It's been 30 days and I have no updates." There are different meanings of no updates. If you truly have no receipt notice, That's unusual but not impossible depending on mail and intake conditions. If you have a receipt but you're waiting for an interview, 30 days is not unusual. It's important to distinguish between no receipt and no milestone. If you have no receipt, you cannot make many official inquiries because you don't have a case number. In that scenario, track delivery, confirm payment processing, and then consider next steps if a receipt doesn't arrive within a reasonable period. Now, I'm going to close with the most important takeaway from tonight. Airport travel is not a neutral environment for immigration. If you are a non-citizen, your safest approach is to be prepared, be organized, and know your risk level before you go. If you have any history that could cause problems, do not rely on guesswork or online reassurance. And if you have optional travel and high risk, consider postponing travel until you have a plan. We could easily continue for another hour, but I'm past my scheduled time. If I didn't get to your question, join next week and post it early so I can address it sooner in the session. Also, subscribe and follow so you don't miss the short videos I post during the week, because many topics deserve deeper explanation than a live chat can provide. Thank you to everyone who joined tonight, both returning viewers and new people. Have a good night, stay safe, and I'll see you next week.